Okay, right. So numbers seem to have stabilised. So thank you everybody for joining today's session. This is an internal awareness session on data breach claims. This is a session that's been recorded. As I say, it is a webinar, so cameras for participants are disabled and you're muted. But we do have a question and answer area at the top of your screen. Any questions as we go, if you want to log the questions, and we'll seek to come to those at the conclusion of the presentation. Session is being recorded, and so for anyone who's missing, we'll be able to pass that on at a later date. The background to this session is that a short while ago, I received a claim for one of my customers for a data breach. I have been with Zurich a few years, as some of you will be aware, and it's the first one that I'd encountered. And to be quite honest, I wasn't really sure where to start, so a few phone calls were made, and I made contact with James Butler. And it's in Stephen McGee's specialist claims team that these cases are handled. And the conversation that I had with James was quite insightful in terms of the number of claims that we're starting to see and some of the behaviours that we're encountering. And it was thought useful as a consequence of that for all market-facing staff to maybe have a session where we can give an awareness for everyone to understand what these claims are about, which claims teams are handling them, and what we should be looking out for. So without further ado, I'm going to pass over to Stephen McGee, who's ably assisted by James Butler and Beth Foster in delivering a presentation on data breach claims. And at the conclusion, we'll pick up on the question and answers. So, Stephen, over to you.
Thank you, Mike. Can I just check you can see the slides first before I get started? Are the slides appearing on the screen?
Yeah. We've got.
Okay.
Got them.
Good stuff. Okay, so thanks for the introduction. Myself and fellow members of the Specialist Claims team, as Mike said, namely Beth Foster and James Butler, will be taking you through this presentation. Should last about 35 to 40 minutes, and then we've got a bit of time for questions. I think you can just pop them in the Q&A box as we go through it. We'll try and deal with most of them at the end, and all being well, might get a wee bit of time back at the end. So let's see how we go on. So the presentation will be pretty fluid, but the agenda here shows the high-level topics we'll be looking at. So firstly, going through the market in general, moving then on to the Zurich experience and the reasons for the increase in volume that we've seen in recent years. I'll briefly cover off the standard policy coverage under Zurich wordings before Beth discusses some typical claim examples. Then James and I will finish off by talking about what these claims worth and what these claims are ultimately worth in terms of quantum and associated expenses. So let's start firstly by looking at the current environment. It feels like every other day at the moment there is news of a high-profile data breach in the headlines. This slide details some of the breaches involving some recognisable brands. Most of the examples here involve cyber attacks by very sophisticated criminals, which is becoming a problem in its own right. Although the companies listed here are well-known profitable organisations, cyber criminals do not discriminate in terms of who they target. Recently, we've had public authorities, education providers and small charities all being impacted by cyber attacks. So whilst the main theme of this presentation will not be on claims resulting from cyber attacks, the prevalence of the issue in the public eye means that it makes it for a pretty ripe area for claimant solicitors who are always looking for the next big money spinner. And it's become apparent in recent times that this is certainly one of them, as we'll see in the next slide, in terms of the Zurich volumes that we've seen, which really demonstrates that. A couple of very recent high-profile instances are on this slide here, like for example the PSNI and Electoral Commission breaches. Zurich thankfully do not have any interest in those, but in more recent times we have been involved in a couple of pretty high-profile cases, which I'll briefly summarise. But just want to make clear that whilst the cases I'm going to discuss probably glamorise the topic a wee bit, if you want to say that, most of the stuff that my team see are pretty low-level nuisance claims involving individual like low-level breaches involving individuals, and it's usually just down to simple employee error at the insured's end. But we do get involved in some bigger stuff as well from time to time. So first example is the British Red Cross, a ZM charity customer and a name that's no doubt known to everyone. They form part of the International Red Cross Umbrella Federation, and that was subject to a cyber attack last January. And that exposed the data held by the British Red Cross. And as you can imagine, given that it's a charity involving that look after refugees and all sorts of vulnerable individuals, this needed to be handled extremely sensitively. And there was a suggestion during the early stages of the investigation that the attack had been initiated by Russian state actors ahead of their invasion of Ukraine, so to disrupt the resultant refugee crisis that followed. There was also a comment made as part of the investigation that China might have also been involved. Ultimately, we never found out who was behind the attack. The case itself was highly political and sensitive, and the customer only really gave us the information that we strictly needed to know, kept us very much at arm's length. But given how serious the incident was, we got involved at a very early stage and tried to support the customer, and we instructed a specialist cyber lawyer to help them with their response to the ICO. Ultimately, the ICO didn't take any action against the customer because there was nothing they could have done about it, essentially. And no claims resulted, which was a bit of a relief, because you can just imagine that if a claim was pursued by a data subject in that sort of circumstance, it would be pretty serious in terms of the resultant impact, and we'll talk about that in a wee minute. Second example is a more recent one involving Greater London Authority, another ZM customer, and this is essentially the London Mayor's office, so Sadiq Khan's office. They were involved in the build of a website for the Metropolitan Police, which allowed victims of crime to report incidents and also raise complaints about serving police officers. After a period of weeks, it became apparent that the website had been left open at the back end, pardon the non-technical technical terminology, but basically if members of the public were sort of looking on the website, they could get into data that had already been input, so they could see details of people's reports, which obviously in a lot of cases would be extremely sensitive information. So recently, all the data subjects were notified that their data had been exposed, and we do expect to see claims in due course, though to date none have been received, but we're only a few weeks down the line, and it probably is inevitable that we'll get a few, if not substantial volume of such. And this is a type of incident which could easily reach seven-figure sums on a cumulative basis, and really links into the coverage discussion, which we'll come on to very, very shortly. So I mentioned the Zurich claim volumes earlier on, so this is the graphic which demonstrates the development of things at our end. Prior to 2015, where it starts, we saw a relatively small volume of claims each year, but it then started to pick up slightly and steadily from there. Volumes really started to ramp up in 2019, then doubled in 2020, doubled again in 2021. However, it seems based on last year's figures and this year's year-to-date figures that we're probably over the peak of it now, but volumes do still remain sizable in the context of our relatively small team that handle these claims exclusively at the moment. So that's Zurich's experience, but based on what we hear from other sources, other compensators are seeing similar trends, particularly in the local authority space, the public authority space, for example, the NHS, where large volumes of personal data are held by organisations. The reasons for the spike and subsequent drop-off in volume will be explained over the next few slides. It will hopefully all become apparent. In terms of the split of those volumes between ZM and commercial, the last time I checked it, it was tracking at about 80% ZM, 20% commercial. However, there is a wee bit of an outlier within the commercial book, and that we insure Lloyd and White, and under that scheme, which is a scheme, and under that scheme we insure a lot of doctor surgeries and dental surgeries, etc. And those are the sorts of organisations that hold large volumes of customer data, some of which is sensitive. So they produce in the context of our team, quite a large volume of claims. So that's probably a bit of an outlier in commercial. Clearly, ZM type customers, public authorities that hold a lot of personal data are more of a risk in this regard. But I guess the point we're trying to make in this presentation is that no policyholder is immune to the risk. So the reason why we've seen the increase in volumes is multifactorial, really. We'll just talk you through some of the main ones. The first and probably most important one was the Court of Appeal decision in Vidal Hall versus Google from 2015. That case concerned the conduct of Google, who were collecting private information about the claimant's internet usage through their Safari internet browser without prior consent. So those of you who are frequent smartphone users can probably relate to this. You're perhaps browsing the John Lewis website, for example, looking for a new t-shirt, and then go off it, and then later go onto Facebook or Instagram, and you're confronted by some targeted adverts from John Lewis or other retailers seeking to sell you a t-shirt. That is not a coincidence, and the chances are that you've consented to share your personal data, sometimes without even knowing. So previously, consent wasn't always sought, and hence Google and other technology companies were in breach of the data protection legislation and received substantial fines as a result. So whilst the background to that case is perhaps mildly interesting, the crucial point to come out of it was that the Data Protection Act Data Protection Act 1998 was incompatible with the overriding EU data protection legislation. So it's pretty complicated and quite boring, but the EU directive was embedded into local law within EU territories, and the UK done that through the introduction of the Data Protection Act 1998. Under Section 13, the claimant was required to demonstrate damage as a result of any data breach. And what that meant basically was that they had to prove that they'd suffered a personal injury or some sort of financial loss to recover damages. On a practical level, that meant that very few cases met the required threshold, and claim volumes were extremely low as a result. The high threshold was no doubt deliberate on the part of Parliament and UK government when the 1998 Act was created in order to avoid large volumes of claims which would ultimately hit the public purse. However, the overriding EU legislation, under that, there is no requirement for the claimant to have suffered damage. To be entitled to compensation, the claimant merely needs to demonstrate that they have suffered distress as a result of the breach. So that's obviously a much lower threshold and is extremely difficult to refute from a defendant's perspective. As a result, it's now substantially easier to recover damages as a result in the case of a data breach, hence why it's become open season for claimants. The only surprise from our perspective was that it took a few years before claimant firms started to sort of cotton onto this and take advantage of it. But the next few points will probably explain why there was a bit of a delay there. So the one in the middle there, the GDPR, that's pretty obvious. That was introduced in 2018, and you probably all remember quite a lot of news coverage and stuff around that. So that did heighten the general public's awareness about what their data rights were, etc. But most probably similarly important to Vidal Hall is the claims management, or the sort of rather claimant solicitor community activity in this space. So it's not receiving as much attention as it has done in previous years, I guess, at the moment, but it has been referred to by some commentators in the market as the next whiplash. That's probably a slightly dramatic take on it, but similarities do arise from the involvement of the same sort of claimant representatives and claims management companies in particular. And when it comes to any sort of claims spike, there's usually no smoke without fire. There's usually claims management activity in the background driving it, rather than anything particularly wrong. The same sort of thing is being feared just now in respect of like mould claims within landlord and the landlord-tenant sort of space at the moment. So claimant firms are very sophisticated and they're always seeking new revenue streams. They're under more pressure than ever to do so for a few reasons. So just sort of bash through these quite quickly. Fixed recoverable costs have been in place on personal injury claims in England and Wales for 10 years now, and that removes substantial income from claimant firms at the time. Fixed recoverable costs and a very strict pre-action protocol have been in place on holiday sickness claims since April 2019. The similarities here are quite telling. This is one of the areas that was targeted by claims management companies after the squeeze on general personal injury claims in 2013. The travel industry was hit very badly by a surge in claims a few years back, with a 500% spike in gastric illness claims received between 2013 and 2016, all whilst reports of food poisoning at holiday resorts remained steady. This was driven partly by a commercial approach to claims by the travel industry, rather than thoroughly investigating and scrutinising medical evidence. They were just settling claims on an economic basis to avoid adverse PR and complaints. But pardon the pun, that only did feed the beast, and it generated a lot of substantial claim volume as a result. CMCs, claims management companies, were camping out in airports, and they were on the streets of holiday resorts trying to drum up business, as well as doing their usual cold calling and spam emailing to generate business. And it got to the point where some hotels in Spain were refusing to take bookings from UK travellers because they were fearing the litigation which may follow. ABTA, who are the travel the travel industry body, and the insurance industry came together and fought back against this eventually, and that resulted in the pre-action protocol being introduced in 2019. But no doubt the sort of cost of that claim surge was passed on to holidaymakers in the meantime. Next is PPI. The deadline for that was August 2019 to the relief of the banks who had been hit heavily by that over the decade or so prior. Thinking back to the previous graph, 2019 is the year where volumes really started to ramp up, and it's probably no coincidence that that's the year that the PPI and holiday sickness gravy train was brought to an abrupt halt. We then had the pandemic, which significantly reduced road traffic accidents. There was less traffic on the roads, so less accidents, obviously. And those whiplash type claims are the bread and butter of a lot of claimant firms. So that sort of starved them of that income. And then we also had the whiplash reforms introduced a couple of years ago, which really strangled the cost recoverability on the whiplash claims generally. Second to last point is the ongoing economic pressures caused firstly by the pandemic and now the ongoing cost of living crisis, which is hitting everyone. So it's possible the people that might not have previously claimed are now having a shot at it to get some money just to get by. And if the option's available to them, then you can't really criticise them for that. And the final point is the commercial approach taken by compensators. And this links back to the holiday sickness point, I guess, though it really applies to any class of claim. If an insurer or a self-insured organisation takes the view that because of quacks or any other reason that it's cheaper to pay claims at an earlier stage rather than thoroughly investigate and potentially defend them, then they will quickly find themselves on the end of a targeted campaign by claimant firms who seize on that sort of weakness and approach. And that is exactly what happened on holiday sickness, and maybe part of the problem here, perhaps. From Zurich's perspective, when the claims were low, we would deal with each case on its own merits, and sometimes settle cases on an economic basis to sort of just avoid litigation, etc. However, after we started being confronted by increasing volumes, we started to develop robust strategies and held our ground on a lot of points. And it seems that the market is now coming together on that, and as we'll explain in some of the slides to follow, we're getting some really good results on a few areas. A couple of quick slides just to bounce through. As I said earlier, this has been referred to by some as the next whiplash. Sometimes I've also seen it referred to as the next PPI. That is definitely overplaying it in the grand scheme of things, but the common theme is the types of firms that are involved in these cases. Simple Google search, which can be shown on the left-hand side here, brings up pages and pages of claimant firms touting for business. They're also advertising on social media. The image in the top middle there is something I've seen on Twitter recently, or rather X, asking me if they'd been affected by the EasyJet breach. They've also got radio campaigns ongoing and are advertising in the red top rags. It's possibly only a matter of time before nuisance calls around this begin, if they haven't already. A quick bonus slide shows an article that we picked up a year or so ago. It concerns one claimant firm that we routinely come across plagiarising the intellectual property of another firm we deal with and having to pay damages to them as a result, which is rather ironic given the type of claim we're talking about. They've basically shamelessly stolen their stock letter of claim. As Beth will shortly talk us through, the letters that we see are all very similar now and are classic copy and paste jobs with only specific factual details being amended on them. Need to be very careful of obviously sharing personal opinions on it, but this article probably very aptly shows the sorts of firms that we're coming up against. So really, this is probably the main part of the presentation for most people's purposes. As Mike said, one of the objectives is to highlight policy cover which is available under our policies, as it's not always fully understood by customers and brokers, and obviously internally as well, because this is quite a niche type of claim and it's handled exclusively by SCT, and a lot of other colleagues haven't really come across it before. So we have seen, probably over the last 12 months or so, an increasing number of cases where customers have reported claims to us very late in the day, and by which point significant costs have been incurred both by the claimant firms, who that's a really good outcome for them if they're dealing with an unrepresented defendant that hasn't passed it to their insurer, or even if they do pass it to their own solicitors, because they can run rings around them and just build up costs in the background. So in a lot of these cases, by the time it's came to us, we're already £50,000 in the hole, and a lot of the time the customer's own solicitors are really are taking them for a ride as well and charging them exorbitant rates for what is a pretty straightforward area of the law when you break it down. So obviously that type of scenario throws up late notification issues, and they need to be dealt with very carefully. But to date, we've been taking the view that not to be too harsh about it, because the customer just simply hasn't been aware that they had cover for such a claim, and they've only realised quite late in the day. And there's no doubt several customers that have been dealing with these claims as they've been coming through the legal departments without passing them to insurers and incurring their own money on them, basically, which could have been passed to us. So it's really just to highlight for those of you in the audience that are market facing, just to be speaking to brokers and customers where, of course, cover does apply under the policies, just to make them aware of this, so that they can get the claims to us at the earliest possible opportunity, where we can mitigate the costs involved and handle them as per our internal strategies. So the wording of the cover on our policies may differ across different customer segments, but it is largely the same and thankfully straightforward, relatively straightforward anyway. So prior to 2018, the position was that cover for data breaches applied under Section C of the operative clause of the PL policy. So this here is from the PL policy. Those of you that have dealt with casualty claims will be very familiar with parts A and B, which covers accidental injury and accidental damage to third-party property. Until I came across data breach claims within SCT, I had very rarely had reason to look at Part C, which has got cover for quite a lot of novel type situations. But it was probably going back 15, maybe even longer, 15 years or so, where the underwriting took the view that the underlined section here, accidental invasion of the right of privacy, responded to claims brought under the Data Protection Act. So for a long time, that wasn't really an issue because claim volumes were limited in volume and value. However, following the Vidal Hall case that I mentioned earlier on, claims became concerned quite early on that that could open the floodgates and engage with stakeholders within underwriting. The concern really is that the cover sitting under the main operative clause, which is subject to the overall limit of indemnity, which in some cases, like large ZM customers, for example, it can be up to £50 million. So we could be leaving ourselves wide open to like very large claims. In the case of large-scale data breaches, some of the ones I talked about earlier on, the subsequent losses can affect hundreds or thousands of people, and they need to be accumulated together because it essentially usually arises from the one event. Hence, one excess will apply and one limit of indemnity will apply. So this is probably the best example of claims and underwriting collaboration that I've seen in my time at Zurich, because we passed that information up the chain within underwriting, and underwriting responded relatively quickly to update the wordings. And I'm just going to talk you through what the new wordings look like, or the updated wordings. So this is the updated wording. It was updated on most commercial policies in 2018 and in ZM in 2020. So just before we really started to see a sharp increase in volume, thankfully. The relative section is again underlined. You will see that the old coverage applies, but within it is a further wording which writes out claims brought under the GDPR and Data Protection Act. So this writes it out under the main coverage, but we then bring it back in under the following extension. So here we're providing essentially the same cover, but it's a bit better defined and controlled. The point to note here is again the underlined section at the very bottom, which capture exposure to such cases at £1 million on a cost-inclusive basis. From an underwriting perspective, this has proven to be quite valuable because we have been notified of a couple of cases like the ones I referenced earlier on, and several others where we've put a substantial reserve on a couple of them, right up at the limit, the loss limit, £1 million. But absent that inner limit, it's referred to as an inner limit. We could have been potentially reserving it a lot higher and then open ourselves up financially. A couple of caveats just to note around that, however. The trigger for this extension is a legal liability under the Data Protection Act or GDPR. It's silent on injury or damage, unlike the main operative clause under sections A and B. As the next slide will explain, however, some claims are presented as psychiatric injury claims, the ones in the more serious end of the spectrum, and sometimes otherwise, rather than just mere distress claims. And where that happens, there is an argument that the main section of cover, section A, which covers personal injury claims, is triggered, although in reality it's unlikely to be an issue because there'll be few and far between the number of cases where that is actually legitimate. The scenario, which I think applies to the one that Mike referenced at the very start, where an employee's data is breached, is sometimes needs to be carefully considered as to whether it's EL or PL. The simple answer is that where an injury is alleged, it'll be an EL claim because it just triggers the policy as normal, which responds to injury claims from employees. However, if it's just a claim for distress, there's no allegation of injury, it'll be handled under the PL claim, under the PL policy rather, and that's because it's silent on the requirement for any damage and doesn't write out cover for employees. It just needs to be that a data breach is alleged. So that hopefully provides a useful overview of policy cover. This is sometimes referred to as silent cyber cover, in that it can provide cover for cyber incidents, but it is limited to any resultant third-party claims, and none of the support that may be provided under a more extensive cyber policy applies. And I know the cyber policy is something that's been sold. I don't know to what extent, but it's been sold in the commercial in the commercial side of things. I don't know how many policies we've got live at the moment, but most customers that come to us don't have a cyber policy, so they're kind of on their own in terms of how they respond to a lot of the incidents. But we will, on a discretionary basis, sometimes like in the British Red Cross and GLA case, decide to get support involved for them on a limited basis, on the basis that if we can help the customer with their response to it, it'll hopefully mitigate the damage and reduce the number of resultant claims. So I'm now just going to give you a break from my voice and pass over to Beth, who will kindly take us through some of the sort of day-to-day examples that we come across.
Thanks, Stephen. So we will now take a look at some of the typical types of claims that we in the specialist claims team see. As you'd expect, there's a variety of claims types. Some of them are straightforward and some of them are not. There are a few common categories which I'll briefly mention here and are also referenced in the slide. We do as a team see quite a lot of emails that have been sent to multiple recipients where the blind copied functionality has not been used, and everyone within that distribution list has unfortunately received each other's email address, and from that it may be possible to work out individuals' names. The distress in this occasion is probably likely very minimal impact. Obviously it is just the individual's name, that's normal, and on occasion it tends to relate to a generic email relating to various requests for information which don't specifically name any individuals. The second example in the slide relates to the incorrect postal address being used. For example, a letter could be sent to number 6 rather than number 8. The content of the letter is clearly central as to the level of stress that may be caused. We tend to have low-level examples, such as a GP writing to an individual confirming an appointment date and time. This does contain very limited personal information. And on the more serious end, we've got a letter which could be referenced to an individual relating to a meeting following social services regarding a child and a potential referral to family court. Clearly, this is obviously a lot more serious and a higher level of distress can be caused to the former. As you'd expect with situations like this, the incorrect recipient doesn't always keep the information to themselves. They can unfortunately circulate this around the neighbourhood, and on various occasions we have seen it where it is unfortunately uploaded to social media. The third example depicted in the slide relates to social services files being left behind in a home of the wrong family by a social worker who can tend to see various families throughout a specific day. The second example mentioned in the above slide does go to certain in relation to a social care file. It does contain confidential and sensitive information relating to that particular family, and if read and shared with other third parties can understandably cause significant distress. And the final example in that slide is the more extreme. An address can be shared with the birth parents of an adoptive child. The birth parents may not legally be allowed access to that child, and their address can be shared, normally tends to be unfortunately by social services, with the birth parents, who could turn up to the address or the child's school and can cause all sorts of problems. As you can imagine, cases of that nature can cause significant distress for the family, and in some cases they may be required to move house, which can, the costs of any house move tend to be recoverable as well as the damages. In relation to the specific allegations that are normally put forward by a solicitor, the obvious breaches of the GDPR, namely Article 5 and the Data Protection Act. The reality is that it should be the only main cause of action on most claims. However, the solicitors do tend to complicate matters in an attempt to seek higher recoverable costs and an ATA insurance premium. And they also throw in elements such as the misuse of private information, breach of confidence, and breach of Article 8 of the Human Rights Act, which deals with the right to privacy. In practical terms, how the claim is pursued makes very little difference to how the claim is dealt with. But other causes of action may also be relevant in some cases, but at the heart of them is usually a straightforward data breach, and damages are assessed on that basis. In a recent case involving a cyber attack on Curry's PC World, the court struck out all causes of action with the exception of the GDPR breach, and on that basis they were essentially irrelevant. In the case of misuse of private information and breach of confidence in particular, they do require a deliberate wrongful act and are normally added in as a means to recover in after the event insurance policy, as that means that it is recoverable. In most cases, the breaches are usually completely accidental errors on the part of the employee or as a result of human error. And I'll hand back over to Stephen, I believe.
Yeah, thanks, Beth. So I know the question most of you'll be asking yourselves is how much are these claims worth? At the risk of sounding like a lawyer, that is unfortunately not an easy question to answer because at present there's not really a huge amount of case law to support us in quantum assessment. So as damages are payable for the distress suffered, valuing how much a claim is worth is very subjective. Unlike, for example, a normal personal injury claim for, say, where somebody breaks an ankle and they go to a doctor, medical professional, and are objectively assessed with an opinion on the scale and severity of the injuries provided. In the case of a data breach distress claim, you are only really given the claimant's worth for how distressed they are. And when that is the case, it's clearly open to exaggeration, particularly when it's close to impossible to disprove from our perspective. And we really just need to put ourselves in the claimant's shoes and consider how distressed an ordinary individual would be by the situation. And even that is not ideal because clearly different people react differently to certain situations. And where one person may shrug off such an instant, another may become consumed by it. And you need to obviously take that into consideration and treat the claimant as you find them, to use that old analogy. However, judgment calls do need to be made, and some of the relevant factors to be considered are as follows: the nature and the content of the material. Beth's already sort of touched on some of this, but in the case of some of the letters she mentioned, each case will be different. Is there a special category of data involved? Does it involve information around health, sexuality, religious views, etc.? Clearly, the more sensitive and personal, the higher the level of distress is likely to be. In terms of the disclosure itself, to how many people was it made and who was it, that is obviously very important. One-off events, is it a one-off event? That's probably likely to be less serious, but if it's something quite systemic, basically like a complete operational failure at the insured's end in terms of their systems and processes that they've known about or whatever, if that's the case, then it's likely to attract higher damages. If it was to reach a court, the court would be probably be less sympathetic towards the customer in that sort of case. What efforts have been made to retrieve and delete the data, and how successful has that been? And I guess how proactive have they been in trying to do that? The longer they leave it, the worse it's likely to become. And of course, the key is the actual impact on the claimant. Most cases are entirely subjective, but we do see some cases where evidence is provided to back up the allegations. For example, the claimant attending a GP with anxiety issues resulting from the incident, and that probably is enough to satisfy the burden of proof in terms of the distress that's been covered. So just want to briefly touch on some of the cases which provide guidance around quantum. So Galati versus the Mirror Group newspapers is the high-profile phone hacking scandal from a few years ago, which may ring some bells. There was a number of celebrities involved in this action, including Paul Gascoigne. Damages in that case range from 85,000 to 260,000, but it's definitely not applicable to the types of cases that we see, because that involved deliberate, malicious, invasive breaches of privacy. But as you would expect, the case is frequently quoted by claimant solicitors in support of their grossly exaggerated valuations of claims. ELT versus the Home Office is probably the most helpful case we have to work with at the moment, but it does still have its limitations also. This case concerned the Home Office's erroneous publication of quarterly statistics about the family returns process, the means by which those with children who have no right to remain in the United Kingdom are returned to the country of their origin. The information was available for approximately 2 weeks before being taken down, by which time 20 different IP addresses from around the world had access to the information. The claimants were fearful of the consequences of the disclosure, and some in particular fearful of intervention by the government of the countries which they had fled. Awards in this case ranged from 2,500 in the less severe examples up to 12,500, in the cases of the more severe examples. As I said, this is probably the most useful case we have to work with at present. There is almost a starting point of 2,500 for any cases where, from our perspective, the claimant has been rationally distressed by a situation, and for the higher awards where there can be pretty serious social services breaches, it sort of puts a ceiling of £12,500 on it in respect of damages, general damages alone, although the resultant costs of having to move house, etc., if alleged, obviously need to be considered as well in addition. But the difficulty is that a lot of the cases do fall in between those two figures, and it's difficult sometimes to pitch where to put it. Is it worth 5,000? Is it worth 10,000? It's quite a tough call to make at times. But we're sort of starting to build up a picture in terms of what certain firms will accept in certain cases to try and inform our strategy around that. Most recently, we've had the case of Driver versus the Crown Prosecution Service, where a very low award of £250 was made. That case concerned the unlawful sharing of information by the CPS to a political opponent of the claimant. The judge did not find the claimant's evidence of distress compelling and stated, "I consider that this data breach was at the lowest end of the spectrum." Now, it's debatable as to whether that case is helpful for us, because it would probably be preferable if no award was made at all. But I guess if they're saying that you get £250 for really low level breaches, claimants must be looking at that thinking, is this really worth my while going ahead with a claim if I'm only going to get £250? But that said, it doesn't stop them having a go on all of the cases we see. So that leads nicely into James's slide on de minimis. So I can hand over to you, James.
Thank you, Steve. So I'm going to talk around the point of de minimis, which is something that's it's an option that's only become available to us in more recent times, as these cases highlight. So for those of you who've done insurance exams over the years or are doing them, it's a term that you might have come across, and it's a Latin term, and the meaning is lacking importance or so minor as to merit disregard, de minimis. And it was first encountered in Lloyd versus Google. Lloyd versus Google was a class action that ultimately made its way to the Supreme Court, and is therefore a binding decision. And it relates to the gathering of data without consent of, I think it was about 4 million Apple users, Apple phone users, and it was a claim against Google for pretty much obtaining data, something what Steve mentioned earlier when you go onto cookies, etc. It's an important decision because the Supreme Court's decision was to reject the action on the basis that there was no damage or loss as to warrant compensation. But the important point, as it says there, is if the court decided that the infringement of the directive and the DPA was trivial or de minimis, it would be entitled to refuse to make such an award. So, we've got an option open here to argue that some of these breaches are actually de minimis, and therefore, even though we might have to accept there has been a technical breach, that we are then entitled to argue de minimis and damages do not flow as a result of it. The final point of that Lloyd and Google point, the threshold would undoubtedly exclude, for example, a claim for damages for an accidental one-off data breach that was quickly remedied. We have to take that comment at face value. How the lower courts ultimately interpret that will and still is being decided. In terms of what you will find is that damages are still payable for one-off data breaches if the data is sensitive and in nature and has clearly caused an individual distress or damage. So it's taken at face value at later stage, but it's, as most of this is still developing area of law. So that the use of de minimis may ultimately mean that we are seeing lower claims volumes, and by arguing this point, and the point was on Rolf versus Veal Wasbras with Vizard, get my words out. As you can see, this was information regarding school fees sent to the wrong email address. It was held that a claim cannot succeed where distress is trivial, and it was commented that no person of ordinary fortitude would reasonably suffer the distress. The only concern with that case, obviously, it was very good for us in terms of once again proving that these cases, if they are trivial in nature, you can pretty much argue de minimis. What this did raise the issue of was the person of ordinary fortitude, and again, for those of you who have handled psychological injury claims over the years, you'll be familiar with the eggshell skull rule, where we have to take a claimant as we find them. And following this, where we are arguing de minimis, we are sometimes seeing claimants and claimant solicitors arguing that a breach that may seem trivial to you or I is actually not trivial to them because of pre-existing anxiety or underlying mental health conditions, etc. So again, it's an area of law that's still developing. Underwood versus Bounty, again a year later, this was the release of trivial data, name, gender, date of birth, and again the court viewed that this did not reach the level of seriousness. So another positive case that we can use when we're arguing de minimis, etc. And the final case that we've got here is actually a Zurich case, and it's one that I personally handled, Giamphi versus Bristol City Council. And what this was, it was about 600 individuals who accessed Bristol City Council's Children's Disability Services. They were sent a generic email address, email questionnaire, I believe it was. No sensitive data within the email itself, but rather than blind copy everybody in, they decided to just copy everybody so everybody could see each other's email addresses. I think Beth referenced it earlier in terms of, is a email address alone, is that sensitive data, or could somebody actually trace somebody from it, is questionable. But one of the claimants actually proceeded on this matter, and it was allocated to the small claims track court, a point that Beth will come on to shortly. But what the claimant in this case actually obtained medical evidence to demonstrate that the breach had resulted in a psychological injury to her, and really surprising and positive for us. The court and the judge in particular was quite damning of the medical evidence, said that it added absolutely nothing. It did not prove any level of distress or injury or anything, and the claim was dismissed. Hopefully, as a result of that, we are not seeing any further claims from this potential group action at the moment, though there is still potential. But I think what this does is demonstrate that even where medical evidence is obtained, it doesn't necessarily then equal damages are payable. And what we ultimately have to do with these cases is look at the actual nature of the breach and whether that was likely to cause distress or harm to a person of ordinary fortitude. And I'll leave final points. DJ Woodburn on that case, he stated that it is for the claimant to prove that any damage sustained is more than de minimis. So it's an argument that we are continually presenting to claimant solicitors, and with some success. And as I say earlier, it's possible that's the reason why we are seeing a lot a lower number of claims even coming through, because claimant solicitors know that we are going to argue de minimis and possibly aren't taking these cases on. Okay, thank you, and I'll hand back to Beth, I think.
I think you caused Beth a fair bit of distress there by saying it was hard doing this slide, James. It's actually me finishing it off, so Beth can rest easy. Final slide, just talking about costs. So I just moved the slide. So appreciate I said we'd speak for 40 minutes. We're now over 45, so apologies for that. I'll just cover this off very, very briefly. We're going back to the claimant community discussion again. This is hopefully being clear from the presentation. These claims are pretty easy for claimants to pursue, and because they currently fall outside fixed recoverable costs, which applies to most other low-level claims, they are very profitable for claimant firms, hence why they're being targeted, as we've said. So if the defendant makes a Part 56 offer which is accepted, we are bound to pay costs, which are presented to us on a highly inflated basis, charging exorbitant hourly rates. They involve counsel, even though they strictly shouldn't be involving counsel because they're straightforward type claims. They're involving investigators to take statements from any witnesses that are involved, even though the evidence is pretty clear that there's been a breach and it doesn't need to be investigated. And on one case, we've seen a bill of £3,000 for the cost draftman to prepare the bill of costs in question. So in some cases, we're seeing costs claimed that are over 10 times the level of agreed damages. Strictly speaking, this is all quite technical, so I won't go into too much detail, but strictly speaking, these claims should be handled under the pre-action protocol for media and communications and be heard out of the High Court. This protocol and claim track, however, was designed to deal with your Galati type cases like the phone hacking type case and high profile defamation disputes. It was a wee bit of a loophole which claimant firms have tried to exploit in recent years by saying that, strictly speaking, this is the protocol which applies, and it's taking some time to sort of argue against that. We've been getting some success recently. So in recent cases, the High Court have remitted cases to the County Court, and on a few have allocated some to the small claims track, which means that only nominal costs can be recovered by the claimant. Claimant firms obviously will always try to adapt to these developments to circumvent the small claims track argument. They're now producing medical evidence on cases where there's quite clearly not been a psychiatric injury. The quality of the medical evidence is highly questionable, and we're obviously challenging that on a case-by-case basis. In some cases, we just don't entertain it at all, and the claim goes away. But it causes us some challenges back and forward. So in terms of how Zurich and the market generally target this problem, it's unclear really what the best overall solution is. Under the extension to fixed recoverable costs, which are just round the corner, data breach claims are captured. However, the rules, for anyone that's seen them, are unnecessarily complex and left wide open for manipulation. So the claims management companies will find a way to force them out of the process we still do retain the argument to put them through the small claims track. So it might actually be better for the claiming firms to put them through fixed recoverable costs, which may ironically end up leading even further increase in volume. So it just remains to be seen how this all develops, and we're currently working on strategies as a team to decide how best to tackle the challenges that lie ahead, I guess. So that is us finished. You'll be glad to hear. So if there's any questions, I don't know if the thing opens up now for people to ask questions.
Yeah, there is a question. There is a question, Steve, in the box from Glenn. Hi, Glenn. Aside from Lloyd and White scheming commercial, are there any other trades, professions generating a concerning number of claims? Beth can possibly answer this, but Lloyd and White is, I will just say, Lloyd and White is certainly from a commercial point of view, is the biggest recipient of claims, mainly because of the nature of the professions that they're dealing with, it is sensitive data. A lot of it is medical records and the like. So when they have an error, it can obviously result in a sensitive breach. So in terms of their sort of it's, as Steve said earlier, all companies are open to making errors and sending documents to the wrong places, etc. But you've got to look at the nature of the business, and something like Lloyd and White, where you've got medical practitioners, by the very nature of it, it's going to be highly sensitive data. So that's the driver there, why we get so many claims. Beth, anything to add to that?
I was just going to say what you just said, James. Normally you find it's normally like the Balins is normally quite thick, like James touched on. Balins and Lloyd and White seem to be the most generators of the commercial line anyway.
Yeah.
Just with records going astray or incorrect records being sent to the wrong patient and vice versa. So
yeah, and just I think from an underwriting perspective, I've been involved in discussions around this over the years, obviously, which led to the inner limit being put on the policies. And that obviously caps our exposure on the really large claims. But if we want to, I don't know what the appetite is around this, but the better solution, if we really want to control the costs around this type of claim, would be to put an excess on a specific excess on the extension. If we were minded to do so, but appreciate that there's careful customer considerations to be made around that sort of stuff. Just noticed an additional question above Glenn's from Zahir. I have a risk for a fulfilment company who send out home test kits for the NHS and GP surgeries, urine and swab type kits. They are provided with the patient's name and home address along with the type of kit to send out. They hold no patient medical data based on the case law to date. In the event of a data breach, how sensitive are home address combined with the knowledge of what test kit they received, completed tests or not? We probably need to have a proper think about that. Again, sounding like a lawyer, but I would say that our starting point on that would be that that's probably trivial information, isn't it, if there was a breach?
Yeah.
But again, James made a very good point about the claimant being treat the claim as you find, or take the claimant as you find them, and if they've got a specific vulnerability, they might have an argument they're entitled to something there. But I think in the case of most claimants, we would say that's trivial data and they shouldn't be entitled to any damages.
Yeah.
Do you agree, guys?
Yeah, I think so. I'm struggling to see where a breach could arise, really. If it went to next door, say, for example, arguably it's not, it's not potentially sensitive data or something just because somebody's getting a test kit or something. Could be. And if it gets lost in the post in some way, then there's even potential to involve others. If it's sent recorded delivery and, say, for example, the Royal Mail lose it or something, then it's involvement of others. Hopefully that helps a little bit.
And I suppose, Stephen, just my point on the excess, the danger would be applying excess and then you're not getting notified of the claims early, potentially, and the insured starts dealing with it themselves. Would that be a danger if we were to apply an excess? Because obviously the de minimis argument, an insured wouldn't have that idea.
Yeah, and obviously on the ZM side, most customers that we deal with that receive these claims have got large excesses, but we're handling under a claims handling arrangement, and that obviously different on the commercial side. So I guess we could put an excess in, but still on the basis that we handle the claims. But I know that's quite complicated. Probably need to discuss that if that's something we wanted to do. But just a point that I've probably raised previously with colleagues.
One other point on that we didn't pick just very quickly is on limitation, which we didn't cover. Limitation is, like most of DPA, is highly confusing. So you could have a number of different limitation periods applying to a claim. For an average, for a normal DPA claim or invasion of privacy, it's 6 years to bring a claim. But then if there are elements of personal injury involved, it reverts to a normal 3-year period. And equally, if there are allegations under Human Rights Act, then a 1-year period applies. So again, just further confusion really in terms of that. But we don't particularly take limitation as an argument, but it's something that we would do in the right circumstances. And again, you would argue from a causation point of view that if a breach occurred, say 7 or 8 years ago, and somebody's only just bringing a claim, has it really caused them a particular amount of distress that they're only now bothering to seek compensation? So just thought I'd throw that in there.
We have had one more question just posted.
Oh, go on.
This is from one of my colleagues. How far down the chain of command in a firm does the accidental policy trigger apply? So if a low-level staff member maliciously discloses data, does the entire organisation suffer by us refusing to indemnify because the disclosure was deliberate?
Yeah, that comes up in the context of abuse claims, as you would expect. So what is, again, it's quite a long answer to this, but I'll give you the short answer. It needs to be the controlling mind of the organisation. So it would be the director, like senior management level, director level, that would have to be involved in the breach, or was to argue that it was a non-accidental act. If it was just like a junior member of staff, then we wouldn't be able to take a coverage point. We actually had a Zurich success last year involving, I think it was Luton Borough Council, where an employee had gained access to a system they weren't supposed to have access to in order to find information on a family member or a neighbour that they had a grudge against or something like that, and they then used that data against them. And the claimant tried to claim that vicarious liability applied against the local authority. The claim failed on vicarious liability on the basis that the act was outside the course of the employee's employment. But we also, I guess the question was around coverage, and we can't take coverage points on that sort of situation unless there's a specific exclusion, obviously, within the policy, which would maybe bite.
I think, Steve, just to add to that, there is, again, if anybody wishes to do further reading, there is a leading case, which some of you may have seen at Morrison's, where there was a low-level employee who deliberately obtained other employees' data and disclosed that maliciously, because he basically wanted to harm his employers because he was in a particular dispute with them. In that situation, whilst the act is deliberate, it's carried out by a low-level employee. So we would never argue that is not accidental from the insured's point of view.
Yep, thanks, James, and probably quite a nice pitch for our next. But this presentation initially formed part of a bit of a mentoring programme that the specialist claims team are rolling out to mentees who are mainly on the call, I think. But the next session is on vicarious liability. So those two cases that we've just spoke about that are in the context of data breach, we'll probably be talking about them on that session, which I think is arranged for the 5th of October, if my mind serves me correctly. So if anyone's interested in joining that, if you're not already signed up for it, just drop me a note and I can send you details. So thanks for that. It's almost like that was deliberate.
And we have reached 3 o'clock, so that is amazing timing. Stephen, Beth, James, thank you. That was really insightful. I hope everyone gained something from that. I certainly did. Anyone with any more questions that follow, please contact myself or Becky Sutton from the Claims Relationship team, or Stephen, Beth, James directly. Thanks once again, and I think we'll call it a day at that. So have a good rest of the afternoon, everyone.
Thanks.
Thanks all.
Bye all.
Bye.